afternoon, everyone. I'm Blair Hess, Director of Communications at the Council of State Governments. Thank you all for joining us for CSG Capital Ideas Presents today. We're going to be talking about the 2020 census data today, what it means for redistricting, and how states are going to be impacted. Our latest issue of Capital Ideas magazine is out. This program is an extension of the magazine. It aims to expand our content for the magazine pages, continue the conversation, and encourage members to get involved. You should have received this issue already in September, but if you haven't, you can view that on the website there. The website's up on your screen. If you don't receive Capital Ideas magazine and you'd like to, you can email us there at capitalideas@csg.org, and we'd be happy to put you on our mailing list. This issue features stories from our members around the country across all different branches of government, reflecting on lessons learned from the COVID-19 pandemic. It also has information on safety protocols for public schools and universities, increasing access to broadband, and how states are attracting new and remote mobile American workforces. Before we get started, I have a couple of housekeeping reminders. I'm sure everybody has all of this memorized by now, but I'll leave it up here for you. Just as a reminder, this program is being recorded. We do that so that folks can see this after the fact, and we'll post it up on our website here in the next week. We ask that you all keep your microphones muted during the conversation, just so that the conversation isn't interrupted. But if you have questions, you're welcome to leave those in the chat. We want this to be a conversation. We know you're going to want to have questions for our great experts today, so leave those in the chat, and we'll make sure that we cover those during the Q&A part of our conversation. Also, if you have any technical difficulties throughout the program, you are welcome to leave that in the chat as well, and we have lots of staff on the call who can reach out to you and get that straightened out for you. So as I mentioned before, we have a great panel of experts joining us today. Lawton Nuss is a former Chief Justice of the Kansas Supreme Court. He was appointed to the court in 2002 and served as Chief Justice from 2010 until 2019. He's a graduate of the University of Kansas School of Law and served in the U.S. Marine Corps. He is also a CSG Henry Toll Fellow as well. Doug Spencer is a professor of law at the University of Colorado Boulder and an election scholar whose research addresses the role of prejudice and racial attitudes in voting rights litigation. He is a graduate of the University of California, Berkeley, and currently manages the blog All About Redistricting. James Tierney is a lecturer of law at Harvard University and served as Attorney General of Maine from 1980 until 1990. He is currently the director of stateag.org, an education resource on the Office of State Attorneys General. Bernie Buescher is an attorney with Ireland Stapleton in Colorado. Formerly, he was elected to the Colorado General Assembly in 2004 and served 2 terms during which he chaired the Joint Budget and House Appropriations Committees. He was appointed as Colorado Secretary of State in 2009 and also previously served as the State Deputy Attorney General. And finally, in moderating today's discussion is our Executive Director and CEO of the Council of State Governments, David Adkins. He joined CSG in 2008 as our 9th Executive Director. He's a former Kansas State Representative and State Senator and a graduate of the University of Kansas School of Law as well. So David, I'm going to turn it on over to you.
Well, thank you, Blair, and welcome to everyone. We are excited to engage in this conversation. I am coming to you from Lexington, Kentucky, where CSG's national headquarters is located. And we're really excited to be able to share the expertise of our panelists today. It was a little over 20 years ago. I had just been elected to the Kansas Senate, and the president of the Senate called to ask if I would take on a committee chairmanship. Of course, being an eager young senator at the time, I thought, well, this will be exciting. Yes, Mr. President, I'd love to be a committee chair. He was offering me the assignment of chairing the Reapportionment and Redistricting Committee. I thought it would be a fascinating exercise, being a student of political science and law. And I took on that 2-year role very eagerly. We received the year 2000 census and began to compile all of the information necessary to take on the task of reapportionment, using the reapportionment numbers to draw new congressional and Senate and House state boundaries. What I quickly found out is that it was the one time when members of Congress were actually reaching out to me and had a very strong interest in carving off one little sliver of their district and adding another little sliver from another district. It was also a time, it's hard to believe that just 20 years ago, but technology was very nascent at that time. Now, the old days of pencil drawn maps, we weren't quite that far removed from technology, but we did have a mainframe computer that was able to run reports if you moved things around. Now, obviously today, technology makes everyone an expert on redistricting, and the opportunities for people to micro process what they would want their districts to be. What I quickly found out was what I thought would be an exercise in just good civics devolved to that adage that if all politics are local, when it comes to the politics of redistricting, they're very personal. It's also kind of remarkable to think that just in my lifetime, the understanding of what states' obligations were in redistricting has changed dramatically. It was only in 1962 that the Supreme Court held in a series of cases in the early and mid 60s, that first of all, reapportionment redistricting decisions by a state were subject to judicial review. They were not political questions to be left simply to the political branches, and would require equal protection would require that states drawing state legislative districts and states drawing congressional districts adhere to the rule of one person, one vote. Up until the 60s, it was quite possible for states to have congressional districts of very disparate populations, and often weren't even required to renew those districts every 10 years as a result of the census. So to think that this is really a rather fresh endeavor for the states, and to think how far we've come since those opinions in the 1960s is an incredible way to frame the interesting task that the states have upon them now. The pandemic delayed the census information, and as a result of that, a lot of states are now looking at special sessions to convene to carry out this important task in time for the deadlines for the 2022 elections to be met. So there is some there was a hurry up and wait feeling to this past year. Ultimately, when the census numbers were released, there's some very interesting revelations embedded in them, and we hope to talk about them today. But we hope you bring to this discussion your questions and your comments. We look forward to making this a conversation. So I would encourage you to use the chat to share with us any questions you might have, and Blair is going to help facilitate injecting those into the conversation. But I want to turn to my fellow Jayhawk, Chief Justice Nuss. And Chief, maybe you could provide some perspective on any of the cases you presided over the years regarding redistricting. In some states, judicial review is required by statute. In other cases, it is only subject to when litigation is brought, but it is very true that in today's world, often whatever maps are drawn are often the subject to judicial scrutiny through litigation that's filed. And as a result of that, the third branch of state government has often been very active in trying to adjudicate these decisions and remain independent of the politics of those decisions. Inevitably, though, whoever wins and whoever loses in those decisions believes that it was essentially a political decision. So it is interesting as states have evolved the process by which they do redistricting. Some have created nonpartisan commissions. Others make it purely the prerogative of the legislature. It's very true when it comes to redistricting. When you've seen one state, you've seen one state. I'd love to hear, Chief, your reflections on how, as a member of the Supreme Court, you dealt with these cases when they came to you.
Thank you, David. A little bit of a history about Kansas in general. In the early days, all the redistricting cases, congressional seats and state legislative seats, they were all reviewed in federal court. And then in 1974, Kansas passed a constitutional amendment. It's now Section 10 of our amendment, of our Constitution, and it says, quote, "The legislature shall by law apportion the state senatorial districts and representative districts on the basis of population," unquote. And then it goes on to say that within 15 days of our legislature agreeing on the redistricting, the Attorney General of Kansas petitions the state Supreme Court for the court to determine the validity of the redistricting plan. Then the Supreme Court has 30 days to rule on that. And if we were to rule that the plan is invalid, then the legislature goes back to work. They have 15 days to try to fix it. Then the Attorney General reapplies to the Supreme Court, and the Supreme Court has 10 days to rule on the new plan. And if we decide again that it's invalid, the legislature goes back to work, and they have 15 days to try to fix it. So basically, our legislature has 3 bites at the apple. Now, after 1974 and this amendment, the state and the federal cases basically ran in tandem. The Kansas Supreme Court handled the state legislative redistricting, and a federal court 3-judge panel handled the congressional. Then in 2012, the Supreme Court was poised to look at the plan that the Kansas legislature had come up with, but they could not agree on a plan. And so the federal court handled everything because the Kansas legislature had no plan for us to review under the Constitution. And this resulted in a case called Essex versus Kobach. Again, a 3-judge federal panel reviewed the congressional redistricting, the districts for the Kansas House and for the Senate and for the Kansas State Board of Education, which under Article 6 of our Constitution is divided up into 10 different districts. So I came to the court in October of 2002, and just about 3 months before that, all of the redistricting decisions had been made. The Kansas Supreme Court issued 2 decisions in April and May, and then the United States District Court, the 3-judge panel that July, made their review of the congressional districts. So to be very honest with you, I have never sat to review any redistricting plan from the Kansas legislature. Nothing happened from the 2000 census, nothing happened from the 2010 census. I did talk with a friend of mine who's a federal judge who sat on that panel in 2002 and got some inside information and background from him. But I don't have any experience in dealing with redistricting review, even though I was on the court for over 17 years. We handled plenty of other highly controversial, politically charged cases, such as school finance, death penalty, abortion, that sort of thing. But as I said, nothing about redistricting.
I don't know whether we could say that you dodged that bullet, or whether we should just mourn the fact that the legislature couldn't get a plan together to get to you. And it does sound like I was better off chairing the reapportionment committee in 2000 than I would have been if it had been a 2010. So I'll feel better about that, since they weren't able to get the plan together by 2010. So, well, Dr. Spencer, let me turn to you and head out to Boulder, Colorado. And your experience with this and your scholarship provides you with a really nice perspective to give us some context and some insights about the 2020 census and sort of how are legislatures, how are states approaching this task this year? How does it differ from previous years, or what sort of unique characteristics are present this year that we should be mindful of? But I'd love to just hear your general perspectives on this task that is at hand for so many states.
Sure. And I just want to say thanks, David, for inviting me to be part of this conversation. I think this is a very important conversation. I'm really learning already so much from Chief Justice Nuss, and he's claiming that he has nothing to share because he didn't participate. In fact, I've just been thinking a lot about state court involvement in some of these issues because of the way the federal courts have addressed it. So hopefully, I'll get to discuss that with him, or we'll talk about that in a minute. I do think that the 2020 census is unique in many ways, and it's also raised some questions and challenges in terms of how the redistricting process is going to play out this cycle. The first most important takeaway, of course, from the census was just the apportionment that, we had 7 states that lost a seat in Congress. That's really reported. I think people are aware of that. Certainly the states that lost their seats are aware of that. New York is very aware of that. They lost their last seat by 89 people. And 6 states gained a seat, and there's some notable trends there. Texas gained 2 seats because of the growth of their population, and Montana gained a 2nd congressional seat. So now they will be tasked with redistricting in the context of their congressional seats in a way that they haven't done for a few cycles. So that will be interesting to watch. And that seems kind of the most obvious implication from what happened immediately when the census numbers came out in the spring. But the lower level census block data that was released not until August 12th has provided some very difficult timing challenges for states. David, you mentioned this in your introduction. There were 9 states whose state legislative sessions had already ended before the census had even released its numbers. And so there's some question about exactly how states should respond to that. Some states recognize that and either called the special session or held open their legislative session kind of pro forma for a while they're figuring this out. Sometimes the result was not so easy. In California, the census data were released technically before the deadline, but only about 2 weeks. And so there was no practical way for their commission to draw districts, but the deadline was baked into their state constitution, and there wasn't enough time to amend the constitution. And so I anticipate there being quite a bit of litigation around the timing, not necessarily because of the timing per se, but because it adds another jurisdictional hook. It adds another way that somebody who's disenfranchised or angry at the outcome of their map in the final go, they can claim, well, it's a partisan gerrymander, or it's a racial gerrymander, or they can say it was passed under a process that violated our state constitution because of the timing in some way. Those cases haven't yet been brought. Courts, the California State Supreme Court has extended the deadline. They just interpret their constitution through the eyes of fairness to give the commission some time to complete their map by the end of the year. But those kinds of challenges, which are unique to 2020 because of the COVID pandemic and because of just the way the Census Bureau was being run and the way that the census had been put together, is going to create challenges this cycle in ways that haven't. The other thing that really stands out to me from this census data happened to be the multicultural dimension of the way race has been reported. So first of all, just the fact that the electorate is becoming more diverse has implications for how we think about extending the political voice to different communities and what those communities are and how we define them. I think is going to require some rethinking to some degree. And then particularly in some states, how state legislatures address the fact that minority populations have grown so fast. So overall in the country, the Hispanic population, Hispanic Latino population, this is self-reported on the census, but grew 23% across the whole country, whereas non-Hispanic population grew just 4%. So that's a pretty remarkable difference. And if you look at example, what's happening in Texas, Texas gained 2 new congressional seats. 95% of the increase in Texas's population, which basically was the reason they were able to get 2 additional seats, was driven by non-white populations, minority populations. And now in Texas, the population is approximately 40% white and 40% Latinx. And how that plays out in the redistricting cycle will be interesting to watch. The preliminary maps don't seem to recognize that particular underlying feature in a way that would be expected. So for example, the current map has 8 majority Hispanic congressional districts, but the map that's been proposed and being discussed only has 7. So it might be the case that you gaining 2 new seats because of the growth in this population, you would expect there to be additional majority Hispanic seats, or perhaps to at least hold steady. But to shrink the number of seats, I think will raise people's concerns under the Voting Rights Act. Of course, the Voting Rights Act doesn't require that you draw a majority minority district, just that you're providing opportunities, but Texas will need to defend that this move is not diluting the votes of Latinos. And I expect there to be litigation, as there has been in Texas every decade, but accommodating that diversification is going to be a challenge for states. And relatedly on that point, there's been a large increase in people who check the box of belonging to more than one race. And this is actually a complicated story because some of this has to do with the fact that in previous cycles, the census hasn't been particularly great at identifying people who might be two different races, and they've taken great strides to improve that measure. But as we compare the 2020 numbers to the 2010 numbers, we see some pretty striking results. So the white alone, people who just checked I'm white only, that population decreased by 9%. And those who reported being two or more races increased from 9 million people in the United States to 34 million people in the United States. And that difference is almost 12% of the overall population. And so the reason that matters is in Voting Rights Act litigation, you're required to show that there's racially polarized voting. And typically the experts in those cases, they look at the white voting bloc and they look at the minority community that's challenging the districts and usually ignore everybody who's checked the other category or the more than two races categories because it's only 1 or 2%. But now if statisticians are throwing away 10% of the data, then those statistical methods that are being used in Voting Rights Act cases are going to be highly suspect and I think are going to collapse. And the court's going to need to find new ways to address the Voting Rights Act litigation. That's a big flag that I'm watching as this develops. And then of course, a lot of this growth has to do with white people who are identifying as white plus something else. And there's some stories about this that you may see circulating in the media. Some of this is due to people who've taken genealogy tests, 23andMe, and then they find out that, oh, it turns out that there's some Native American blood in my ancestry or some Black blood in my ancestry from 100 years ago, and they're checking the box. And that may actually be more accurate in terms of what our underlying population looks like, but it does raise questions about whether the census racial categories can be used to reliably identify communities who have been discriminated against and oppressed in society in previous cycles, which is the goal of the Voting Rights Act, to overcome that. And if the census racial categories aren't the most reliable indicator of individual groups, racial groups that have been discriminated against or not, if there's people who've grown up in a white community and identify as white, but now are in a category saying that I'm white and something else, and they get identified as somebody who has a history of discrimination, that's going to challenge some of the underlying assumptions and motivations for Voting Rights Act litigation. So that diversification, I think, will be a big challenge, not only for line drawers, but also for lawyers after the fact.
That's really interesting to me, Doug. I want to drill down on just a few things. One is a nerd's question. The courts have said, as much as possible, one person, one vote, that the citizens of the United States should have essentially the same power in selecting their representative to the House. And yet, they recognize that state boundaries are sacrosanct in the apportionment of the 435 members of Congress. And so, to what extent are there one-member states in the House that essentially skew, I mean, I guess at some point it's an issue of equity, but skew, if you have Vermont that has one or Wyoming that has one, are there any inequities that arise just as a result of that? And are there legal scholars that posit some other sort of apportionment that would extend beyond those state boundaries? Or is that just a recognition of the political decision and the sort of sovereignty of the states?
Yeah, it's a really fascinating question. The Supreme Court specifically has said on multiple occasions, we recognize that apportionment and the one person, one vote process and value should be enforced within states basically to as close to perfection as possible that every congressional district has, down to the single person. And for state legislative districts, maybe there's a little bit more wiggle room because it's harder to draw more lines that have equal population with maintaining counties, but really as close as possible. And we recognize that what happens in Florida and what happens in Wyoming is going to look unequal. And the Supreme Court's just basically thrown up its hands and said, we don't have a strong normative view about fairness. All we can tell you is that the country would not exist had there not been a fundamental compromise at the founding that required us to have big states and small states and a House and a Senate that create some of these inequities. Now, we typically focus on the Senate because of its requirement for 2 senators per state. But there is an underlying requirement that each state is afforded 1 representative before the apportionment happens. So the apportionment actually is not a calculation to distribute 435 seats. The apportionment's actually a distribution of 385 seats, because 50 states all get their representative, their baseline 1 representative before that counting happens, under federal law 1941 and under the reading of the Constitution. So there are some scholars who have advocated eliminating that first step and not mandating that every state automatically get 1. But that, I think, would be challenged, and I don't think the Supreme Court would accept that move, even if Congress were to pass a law, because of the nature of this initial compromise, where they recognize whatever inequities are built in the between state comparisons is just something we have to live with. And the Senate cannot be amended. There's no way for us to amend the Constitution to change the Senate. It explicitly says you cannot change the number of members in the Senate between states. So it's one of these places where there are inequities. The inequities can be diminished if we increase the size of the House. So, instead of stripping Wyoming and Vermont of their 1 representative and saying, well, those citizens need to talk to people in Utah and Colorado or New Hampshire and Connecticut, if we increase the body from 435 to 635 or 835, then the differences between, the Wyomings and the Californias those districts would shrink significantly.
You normalize it from the lowest population state to the other. That's interesting. And it has consequences in the way in which the electoral college delegations are calculated. And so I think there's a lot of scholarship now emerging about anti-majoritarian things that are hard baked into our Constitution. From a perspective of CSG advocates for the states, we obviously would be in a position of advocating that each state have a voice in Congress, that's part of the original design. I guess if I can just ask a question about the census generally, there's a lot of reporting that talks about underreporting of certain populations or people. There's also the difference between persons and citizens. And I wonder if you might just tell me, in the world of people that talk closely about the 2020 census, I remember back to 1970 when my mother in Salina, Kansas was a census taker, and she had a little thing that looked like a mail pouch, and she went around house to house and filled out the long form for those people who were selected for it. You realize now with technology, people mailing in their census, there's just you add to that universities and prisons, there's just always sort of an error rate, a factor that you just build in. How much confidence should states have that their numbers are the numbers?
Well, on kind of a nerd data level, there are statistical ways for the Census Bureau to make adjustments, reliable adjustments that have been proven statistically reliable to improve the census counts. But time and time again, the Department of Commerce and Congress has prevented the census from implementing those kind of statistical readjustments. Whether because of readings, and the courts have not demanded that the census do that. They've said it's up to the census and Congress to make that determination about how far to deviate from forms and allow some statistical adjustments. So as somebody who's familiar with statistics and uses them and has watched this closely, I'm an advocate allowing the Census Department, in fact, even requiring them to create the most accurate count they can, even if it requires using adjustments based on surveys of who's living where in empty households, et cetera. And they do a little bit of that, but not as much as they could. That said, when you ask how much should the states trust the census numbers that come to them, my advice would be 100%. I think that litigating 100 people here, 10,000 people there could take 7 years and millions of dollars and maybe lead to marginal changes. And in my opinion, and this is just my opinion, states would be better off to just take their lumps if they feel something they're upset with, or recognize that there could be small shifts here and there and say, this is the number that we've been given. This is the number that will go down in our historical record books as the number of our states. Let's make the most of what we have. But again, there are people who have strong opinions in other directions, which I completely respect. That's just the way that I would suggest that states move forward with this.
Gotcha. Interesting. And Doug, one final question in this particular round, but I often get asked when I'm speaking or out at a particular community event and speaking on a particular topic, often the question is, so which state does this the best? Which state has the best foster care system? Which state has the best highway system? And I know a lot of people track all this, but as you're aware of the many ways in which this is done, and I'm not asking for anything other than just your opinion for whatever reasons you have, but if you had to say to a group of state legislators, here's a state you ought to go look at. It seems to work about as well as any. It seems to be efficient. It seems to be fair. It seems to address concerns about equity. Do you have one that comes top of mind, or is it such an amalgam of differences that it's just hard to pick one out? I don't mean to put you on the spot, but just wondered if you have one.
No, but you're going to call me a homer, but I'm going to focus on Colorado.
Okay.
And I'll just acknowledge, I only moved to Colorado about 8 months ago. I was living in Illinois for 2 years, and prior to that, I was in Connecticut for 6 years, and prior to that, I was in California for 10 years. And I grew up in Utah, so I've been around and I've seen a few different states. And I now am an election law professor, and I live in Boulder, Colorado. And we just went through a redistricting process for the first time with an independent redistricting commission. It hasn't been perfect. There are people who are concerned that the Hispanic population in Colorado could potentially have a stronger voice in our state. The commission was aware and actually has drawn a very competitive district where Hispanics comprise a very large proportion of that district, but there are still concerns about that. And I know Bernie's going to be up here in a little bit, and he's been around Colorado a lot longer, so he may know more of the skeletons in the closet. But I will say the process was not, was filled with vile anger, partisan hatred, the polarization that we're seeing gripping our society in other states, with commissions like in New York, where the commission couldn't even agree which preliminary map to put out, or Virginia, where commissioners walked out of the room and they couldn't even agree on the data firm they should hire. So there was a Republican firm and a Democratic firm, and they're just typing numbers on the computer, not actually doing analysis. So I've just been very impressed by the way that the process went down. There's no right way to draw districts. I mean, that is the ultimate takeaway. You can have proportional representation, you can have competitive districts, you can have majority minority districts, and those values cross-cut, and you can't have everything. And so you can't judge a redistricting system by its outputs. I think it's more important to look at the process that people went into, because if we want competitive districts as our value, then you can't complain after the fact that we're not proportional, because that wasn't the value we went for. Yeah. And I think the way it's happened here has worked pretty well. And I would, and I know political scientists have actually run systematic studies of our vote by mail system and all of the ways that Colorado runs. And it really does seem to be a state that's been able to operate the kinds of election systems that people feel are full of fraud or have been kind of the focus of the rantings in the popular press, but has actually on the ground worked pretty well. And it's a state that has been shifting from red to blue. It's a purple state. And so there's still a very strong competition between the parties. And so, like I said, I might be a homer, but I'm not from here. And I just have been impressed in the few months that I have been here, how well things are run.
That's interesting. Yeah, I found when I was chairing the reapportionment committee, it truly, that competing number of interests, it depends on which lens you were looking through, but it felt like a Rubik's Cube, that just when you moved one to think, oh, well, I'm making progress, you'd turn it over and you'd realize you've just screwed up what you thought was this immaculate design. I guess you could think of it as a balloon animal where you squeeze here and it, it's just, I felt like I was always playing whack-a-mole and trying to please so many people, and it just threading that needle was so elusive. So I appreciate your willingness to be a homer and let us know that. So let's check in with our friend from Maine, General Tierney. I know you have the perspective of an attorney general, and as general have, as Lawton Nuss said, in Kansas, there's a prescribed role for the attorney general, but I'd love to hear your take on your participation in redistricting in the past and some of your thoughts about it.
Well, I'm not really here to talk about Maine. Maine's all done. We wrapped it up in a few weeks.
Put a bow on it.
But since the time I've left office, I've spent the last 30 years studying AGs around the country, and I'm pretty familiar with all your states and the backgrounds and how the role that attorneys generally play. So let me talk a little bit more generally, rather than talk about where I
Perfect.
am now, which is my hometown. AGs break down into two questions. I'm not sure which one you're interested in. The first one is, what could attorneys general do? And what will they do? The first answer is long. The second answer is very, very short. If you want to know what the AGs are going to do, and then you can just go on to our other experts, is they're not going to do anything. And when I say they're not going to do anything, they're not going to do anything that crosses their own party lines. They're all either Republican or Democrat, and they're not. That doesn't mean they're going to be partisan. It's just who they are. It's what they really, really believe. They want their side to win. I mean, most of us on this call have been on the ballot one time, and let me tell you something. Even though I favored election day registration and mail-in ballots and all that kind of thing, when it came down to election day, I only wanted the people to show up who were going to vote for me. Everybody else could just stay home. All right. I mean, that's the truth of it, right? Nobody wants to say that, so I can say that out loud. You, David, you didn't want people going to vote against you to show up that day.
If you're running for class president in the 7th grade, you're hoping that those that don't like you are. Yeah.
So this is, so at that level, the attorneys general are on a team. Now, that does not mean that everything they do is partisan. I want to really make that clear. They're highly professional on both sides. They're really, really good lawyers. But at the end of the day, they want the team to win. What could they do? Attorneys general are set up deliberately in our state constitutions in order to be a check and balance on the rest of the state government. Okay. And it goes back to colonial times, but the bottom line is you don't want the governor to be able to tell the attorney general what to do. You don't want the legislature to tell them what to do. You don't want agencies to tell them what to do. You want the attorney general to step back and say, wait a minute. Our job here is to make sure that the processes are fair, the Constitution is upheld, and then you can all go fight it out. And then whatever you come up with, we'll defend you in court. That's our job if there's litigation. And along the way, if you have questions, we can help you with a formal opinion or an informal opinion. And when it comes to redistricting, AGs have all of that capacity. AGs could speak up on redistricting. They could actually appoint, if they wanted, their own commission to draw maps and lines if they wanted. They could continually advise on the shifting Supreme Court decisions as to how close is enough. They could do it for federal races and state races and local races. They could do all of that. Now, in addition, what they will do, they're not going to do very much because there's plenty of other people doing it, right? I mean, you know, everybody has an opinion, as you pointed out brilliantly. I think because of the technological changes, everybody knows whether this side of the street should be in this district or not, because Harry and Mabel live on this side, and you know, Joe and Caroline live on the other side, and it's astounding what you're able to do from our days, the old days when you sat there with pencils and tried to make a guess. So everybody's an expert. Both political parties are all bulked up. This may be a shock to everyone on the call here, but we don't seem to have a shortage of lawyers involved in this. I mean, there doesn't seem to be a shortage of lawyers. Doug kept saying, it was interesting, Doug, in your presentation, you kept saying, it'd be interesting to watch, interesting to watch. Well, interesting if you're you with a PhD in it, or if you like to watch knife fights and train wrecks and everything short of violence in the street. If you're interested in watching that kind of thing, because that's what redistricting really comes down to. As you pointed out, some states just can't function. They can't speak to each other at all on anything else. So why should they be able to speak to each other in redistricting? So AGs, even though they're the experts in the law, even though they're required to represent state government and to give advice, it is so tense. So let's say an AG gives a formal opinion on something. It could be any redistricting issue. You know, the people who like it's going to say it's brilliant, jurisprudential, and great scholar. And whoever wrote this must have gone to fancy law schools. Whereas people don't like it, say, it's just one person's opinion. I'm not going to pay attention to it. And it used to be only the attorney general would represent state government. But when it comes to redistricting, the state house hires their own lawyer, and the state senate hires their own lawyer, and the governor hires their own lawyer, and so they're bombarding our judiciary, or whoever the federal or state judiciary are, with all these endless memos and briefs. It's just, you know. So good luck to those of you who have to decide those questions. But I would not expect a very prominent role from it. They will do their job. The Kansas Attorney General will indeed certify, right? They will do their job. But if you're asking them to stand up and make grand statements, it's unlikely. Now, before the process on the census, They were very active. After all, it was New York versus the Department of Commerce that had the Supreme Court rule 5-4 that the census could not just have a question on the questionnaire to ask about your citizenship. That was a state attorney general who did that, and 17 attorneys general weighed in on the other side. Not surprisingly, the Democrats were on New York side and the Republicans were on the other side. So this leads to a kind of, in my view, a weakening of the AG brand. I've said very often that, you know, if an attorney general acts like a congressman, they can be treated like a congressman. So that is a branding issue for attorneys general. So I hope they cool their jets, and sometimes they listen to me, sometimes they don't. And just a final note on Colorado, I'm so pleased, Doug, that the system in Colorado is working so smoothly. But if you go back to 2003, of the Attorney General of Colorado, Ken Salazar sued the Secretary of State at the time, as a person by the name of Davidson, went to the Supreme Court. There's all kinds of litigation, which created sort of the framework in the background for the system, which works hopefully well today for all of you people. So sorry, Dave, it's not much of an answer, but it's kind of what I got. You want to know what the AGs are going to do? Not very much.
Well, James, let me ask for your behind the scenes insight, sort of an Attorney General confidential. It seems that the role of the Attorney General in recent years has morphed in that political space. We now know that Attorney General races are attracting national attention,
Right.
and national money is flowing into
Right.
general's races that previously were sort of sleepy political endeavors that attract a limited number of donors outside of the state. And we've seen increasingly, depending on who's in the White House, the tribe of AGs that will sign on to these very political sort of pieces of litigation,
Sure.
whether it was the allegations of election fraud in 2020's presidential election, or any number of things from, they tend to be very politically motivated, in which if a Democrat's in the White House, the Republican, you can anticipate there will be 20 Republican AGs signing on to
Right. Well,
unified litigation.
I can help you with that. It's not really a
Okay.
redistricting question. I think there are several factors. The first is our United States Supreme Court, when they ruled in Citizens United, for whatever they decided,
Yeah.
I don't think it ever crossed their law professor minds. So all law professors, right? All expect, Doug, everybody in the Supreme Court is a law professor. I don't think it ever crossed their mind to even look at state and local government. I do not think they understood at all the implications of allowing unlimited money into races for prosecutors and for elected judges. And so it took a while for that to happen, but now you have that capacity to funnel dark money into these sorts of races, school board races if you want. And so that is a very, very, very negative result. It takes away from state government the opportunity to regulate their own campaign financing around prosecutors, for heaven's sakes, district attorneys, attorneys general, judges. It's just wrong. Secondly, most of the money comes in because of large consumer cases and antitrust cases where even a single state can have it, as we have a more integrated economy. I think that drives a lot of the money, and I can talk about it, but it's probably not relevant, particularly for this group. In terms of the sign-on letters, everybody's got to raise money, and so both Republican and AG organizations circulate these sign-on letters. They're just that. But I want to not overstate it, okay? Because an AG signs a sign-on letter doesn't mean that it's changed the underlying policy or litigation position of that office. It is just that. It is a letter, and increasingly you have amicus briefs like that ridiculous brief to try to overturn the election, which was written by Kansas's own Chris Kobach, wrote that brief and circulated among the 19 states that decided they were going to overturn the election. That kind of thing, I think, is a result of the moment. We turn around, we have these elections, we have Bush v. Gore, we have these kinds of things that come along every 20 years, hopefully never come around again, in which even the AGs forget their job and just kind of go out there and just do grossly partisan things. If you don't, it probably is going to cost you your career. So that's the kind of thing, if you don't really sign up for the big ones, well, let's just hope that never happens again. Down there in the trenches of the AG's office, good lawyers, working hard, rolling up their sleeves, and really not paying a lot of attention to any of this stuff.
Yeah, that's so true.
And we're really, really lucky to have them, because time and again, they save state government from making serious legal mistakes. Well-meaning state agencies who are overstepping their authority, the AGs push them back. I think it's a great institution. I'm very dedicated to it. But you've got all the political claptrap at the top. And
Yeah, whether
start with the Supreme Court and work down on that. Sorry, you hit me on a speech. You got to.
I appreciate that. But when you think about the broad range of what attorneys general do, from consumer protection to human trafficking to criminal prosecutions, all those things. It really is the depth chart in an AG's office that has some of the best public servants you could ever hope.
And very nonpartisan, David.
Yeah.
When you get down there, when I tell my students, if anyone asks you, if you're applying for a job at an AG's office, whether you're Republican, Democrat, walk out the door, because you don't want to work in an office like that. And they never ask that question. Yeah. They're there to do the people's business. I'm very, very proud to be associated with them.
Yes.
David, before you leave that subject,
yes,
Mr. Tierney mentioned one of the parties in that lawsuit that I referred to, Chris Kobach.
Yes.
And I just wanted him to know, if he was not already aware, that Mr. Kobach is running for the Kansas Attorney General position.
Oh, I'm very aware of that. And as is everyone else. And he can't wait because he'll make it his little preaching. He'll just go off and do this thing. He also has some substantial primary opposition, and I don't get involved in these races, but if I did, I'd contribute to every primary opponent.
I'm just curious, given your acknowledgement of that, do you feel he's going to fit that mold of the typical?
Well, some AGs only really aren't interested in doing their job. I'll be very blunt. I'll name a few names. They are not interested in representing their state. They're already transfixed on this national mode. So we saw Josh Hawley get elected Attorney General in Missouri. He brought his pollsters and his consultants into his office in a very unethical way to poll which case would look better for his race for the U.S. Senate, which started immediately, actually before he was sworn in as AG. So when you get people who don't care about AG, there's not much you can do about it. You have to deal with whoever the voters send you, right? Chris Kobach, I've never met him, would seems to me everything in his career would fit into that mold. He wants to be a national player. It's a bad thing to elect an AG liberal, and we've got some liberals who want to do the same thing. If Tish James runs for governor in New York, you're going to see some people who just want to be national players and use the AG's office for that. That is a very, very bad choice for the voters. We need an attorney general who cares about giving legal advice to you as a Chief Justice. You need to rely on those assistant AGs in front of you and their work and their equity and their ethics. And I'm sure, knowing Kansas as I do, you probably had some fabulous state assistant AGs in front of you year after year doing their job. But when you get somebody who just wants a national thing, then we're in trouble. But that's elections. That's why we have elections, I guess, right?
Yeah, well, let me turn to Bernie now. And from his perspective, we return to Colorado, but Secretary Buescher, I would be interested in, from your perspective, what insights can you share about the redistricting reapportionment process that would be valuable to folks that are considering their role in it in their state?
Well, thank you, first of all, for inviting me. I must tell you, I would pay to sit and listen to these other three folks talk, because it is just fascinating. General Tierney, I worked for John Suthers for a number of years, and you sound so much like him in your passion for nonpartisan representation.
A truly great Attorney General, John Suthers.
He is a wonderful person. Right. I'm also blessed to have been good friends both with Donetta Davidson in her prior service as secretary, and Ken Salazar, and you referenced the case Xrel Davidson, in which Ken Salazar sued his own client. And I mention that because that is the type of thing that happens in redistricting. And about 4 years ago, a group of us that had been in the legislature and had dealt with the aftermath and the anger and the hard feelings that came out of the 2010 and the 2000 redistricting, said that there's got to be a better way to do this. And we came up with a way of structuring a redistricting commission, giving it certain standards to operate by. And we are just finishing that process. Our commissions, both for separate commissions for congressional and stateside districts, both are composed of 4 Republicans, 4 Democrats, and 4 unaffiliated. And folks said, you're not going to get unaffiliated that are going to do this because those folks aren't really involved in these issues. And that proved to be wrong. And we said, these commissions have to make their decisions by a supermajority vote, 8 out of the 12, including not less than 2 of the unaffiliated have to approve the maps. And we were all worried about whether that type of consensus could actually be created. We required the commissions to meet all over the state, approximately 50 hearings. We required that the maps be drawn by the nonpartisan staff at the Capitol that works for the legislature, but is nonpartisan, much like the AG's office, rather than by the parties. We prohibited people who had been elected officials in the last 5 years or members of party hierarchy in the last 5 years from being on the commissions. We also said no to others like lobbyists. We were fortunate that the process worked. The folks that were chosen for these commissions, and half of them were chosen by lot, just out of the qualified applicants.
That's interesting.
It took them a while to figure out how to work together. These folks weren't familiar with Robert's Rules of Order. They weren't knowledgeable about how to make a motion even. And they had to learn all of that. And they made some missteps. But after considering 3 sets of maps sequentially, after holding hearings all over the state, and after an incredible amount of long discussions, which were respectful, hardly ever heard anyone raise their voice. The congressional map was approved by a vote of 11-1. The state Senate map was approved by a vote of 12-0, and the state House map 11-1. Our process now provides for those maps to be submitted to the Supreme Court to make sure that they comply with constitutional and federal statutory and state statutory obligations. The congressional map has already been submitted. Briefs were due last Friday, and we'll have a decision on that map in a couple of weeks. And the state side is just a few weeks behind that. But the thing I'd like to share is that folks that aren't beholden to the political parties can make good decisions. In fact, I believe make better decisions than folks that are beholden. And I love the comment from Professor Doug Spencer, and hopefully we're going to be able to get together because our process is working. And I think it is a model that other states can emulate. A couple of things that I would share. One of the things that I was fascinated at, there's been a lot of talk about the way that the census is resulting in a number of states getting a total of 7 additional members of Congress, and some states lost. But there's also some changes that I think are apparent on the state level, which are going to be very interesting to see how these play out. In Colorado, we're losing both some state Senate and state House rural districts. It's been well documented nationwide. We are seeing people moving from rural Colorado, and I live in rural Colorado. They're moving to the urban areas. That's going to change the makeup of state houses and state senates in Colorado. It probably cements a slightly stronger Democratic presence and a slightly weaker Republican presence. And I'm very, very interested to see how that plays out on a national level, because that may change some of the dynamics on redistricting going forward. We're excited in Colorado about the way that these commissions have worked together. There's a few folks, perhaps the most partisan in each party, that don't think there are enough Democratic safe seats, or don't think that there are enough Republican safe seats, which is really what both parties angle for. But right now we're pleased with what's happened in Colorado. So I'll stop there.
Can I
Bernie, I
jump
wanna-
in really quickly, David?
Yes, please do.
You know, Bernie spent so much time talking about the process and the way that it built up. And I flagged this because I was reading an editorial in the Wall Street Journal this week by the editorial board criticizing independent commissions. And I think, as Bernie points out, you know, not all commissions are created equal, and not all independent commissions are independent. In Virginia, for example, which I wish that the Wall Street Journal had clarified, half of their commission actually is sitting state legislators. And state legislators are not bad people. They're amazing people, but they have different motivations, and they come to the table with different goals and communication than just ordinary people. And as Bernie mentioned, some people here were chosen out of a hat. And so the institutional design of these commissions can play a major role.
David, I had a question, if I may.
Sure.
Professor, because he said he needed to leave in about 10 minutes. My question is this: I just want to make sure in our discussion and what our audience is hearing is that nobody thinks we're focusing on the congressional districts and not paying sufficient attention to the state House and the state Senate. And the reason I wanted to bring that up before you left is because in looking at some of the United States Supreme Court decisions, for example, the Brnovich decision that came out just a couple months ago, they're talking about things that the state legislatures are doing that have an impact on voting. And that is things that we're reading about across the country. In that particular state, they were talking about you're not going to have as many drop-off ballot boxes as you used to have. We're not going to allow you to provide water to people standing in line who are trying to vote, those sorts of things. So I just wondered if, before you left, Professor, if you could talk about that briefly and then maybe ask the other panelists to chime in. I just didn't want people to get the impression that we're mainly talking about congressional districts and what's going on in Washington, D.C. So thank you.
Absolutely. I'll just say a couple things because I do need to run to teach a class in a few minutes. You're absolutely right. I think it's easy to talk about congressional districts because there's fewer of them. It's a uniform story between the states. You know, for example, the congressional map in Oregon, which was drawn by the Democratic state legislature, was just challenged by the former Republican Secretary of State. And kind of getting to what John Tierney was talking about, it's a national conversation, right? Oregon Democrats feel obligated to help Democrats maintain the House of Representatives in DC. New York Democrats feel the same way. Illinois Democrats feel the same way, and Texas Republicans. And so they're looking beyond their state boundaries and to add some interesting, but I guess maybe bloody knife fight and train accident type salaciousness to the story that makes it easy to focus on. But you're right. The rules that will affect our lives, and this is why I think, you know, to Bernie's point in how things worked out here in Colorado, our state legislative and state House districts followed a similar process and had a similar outcome. And dealing with local issues, we're not thinking about maintaining a majority of Republicans or Democrats in Washington, D.C., but we're worried about rural interests in the southern part of California and the western parts of Colorado and the western range of Colorado, relative to what's happening in the center of the state, Denver and Boulder, et cetera. And I think you're absolutely right. And I think a reason in particular to focus on this is that as we move forward, the US Supreme Court, not only in Brnovich, but in these cases that came up during the 2020 election challenge, signaled a strong deference towards state legislatures in the way that they will go about conducting their business. So that legislators now, I think, have a much larger role to play, because it will be more difficult to challenge the kinds of laws that they pass, redistricting or other kinds of election reform, because of the way that the Supreme Court interprets the US Constitution to afford them. So focusing on the states not only gets you closer to the issues that touch our hearts and our lives, but actually gets closer to where all of this action is going to take place. More of the litigation will be in state courts. More of these rules are going to be coming out of state legislatures, and federal courts are going to defer.
Yeah, and it's clear we're testing the bounds of the supremacy clause with some of the actions states are taking right now. But it is also true that we are a divided nation. And when you have a House that is just a sliver of control, being a handful of folks, every congressional district matters, and therefore every state's process matters. You know, I can remember when I was doing this in 2000, I got a call from Karl Rove, and I thought, why would he be calling me? He had a war room where he was looking at every district, even in a safe state like Kansas that was so Republican. They were still trying to engineer that down to every particular seat. But that division in DC, we also know, leads to gridlock, which means most of the decisions about public policy are being shifted to the states. And therefore, on a national level, people are very much interested in who will control a particular state legislature, because they know there are particular policy choices that one party will make that another party won't make. And in places like Oregon and Washington, when you have one part of the state that's blue and one part of the state that's red, it's also a place where you feel like you're really struggling to hit the right note.
David, one of the...
Yeah, I wanted to ask you, Bernie, because the professor had helped us with this. You know, the outcomes of the process depend on the lens through which the participants are looking. And I'm interested, you know, it was clear that Colorado was a hot mess for several generations of redistricting. That led to an interest, a consensus to say there has to be a better way. Two things I was interested in is what lens seemed to emerge that became a driver for the commission. Did they make more compact districts? Did they look less like a Rorschach test, and they became less disaggregated in some ways? And I'm also interested in who were the stakeholders that would have supported this commission. Did businesses support it? Was it more of the League of Women Voters and the Good Government set? Was it subsidiary governments, you know, cities and counties and schools that said, we have to have more coherent strategy here? I'm just very much interested in the politics of how did Colorado get this passed? So I'd be interested in how has the commission changed the approach or the priorities, and then who made it possible to right the ship?
Yeah. The first question, the commission, like everyone who does this job, struggled with what was a community of interest.
Yeah.
And how to recognize those communities of interest. That was probably the most challenging discussion, and that in fact should be the most challenging discussion. Now, the one that fell by the wayside, and my only real criticism of the commissions, is the language we put into our Constitution directed the commissions to create, quote, the maximum number of competitive seats. And we really didn't get any increase in significant seats. On the congressional side, we've got one competitive seat. On the state house and state senate, we've just got a handful. We felt that was one of the keys to creating a higher level of civility, forcing members of the legislature to work together better.
And move to the middle. Yeah.
And move to the middle, exactly. Now, how did this happen? The the story is 4 of us who'd been in the legislature, 2 former speakers of the House, and 2 of us that had been chairs of the Budget Committee, got together, talked about the things we had failed to do while we were in the legislature. And tops on that list was redistricting. We came up with 6 principles and we started shopping them around. We found a few supporters, and mostly the parties were very, very much antagonistic. We submitted an initiative, went to the Supreme Court, got knocked down, redoubled our efforts, went back, submitted a second initiative, and they realized that we were serious and we're going to go through with this. And we all got around the table, and we had approximately 75 meetings over the course of 6 months on the language, agreed on the language, and then asked the legislature to consider it as a referred measure. And amazingly, because at that point, no member of the legislature could vote against this. The editorial boards were saying this is a good idea. The League, Common Cause, the Denver Chamber, all had said, this is a good idea. This is where we should go. Nobody could vote against it. So it passed 100-0. And then when it went to the voters, it got over 72%. Sometimes you can back the legislature into a corner appropriately. And I think that's what our group did.
Bernie, I don't want you to Monday morning quarterback yourself, but looking back on it, now that you've seen a cycle, is there anything you would have changed about it? Anything that should have been more overtly required, or guardrails that you would have put up now that you've seen how it works?
Well, I'm going to spend a lot of time thinking about competitive seats. I think that's important, but we had to put that as a factor behind the constitutional and the federal statutes, of course. But if there were one change I'd like to figure out is how to create greater encouragement for that. Nationally, and this is true in most states, what is a community of interest? And is that in Colorado, is that a watershed? Absolutely. That's very, very important.
Mm-hmm.
But I think on a local level, you know what real community of interest is? It's where your kids go to high school.
Right.
It's the high school team that you cheer for.
Those rivalries, yes.
Yeah, you're right. But we don't use that. That's not our mindset. And I would like to be involved in a good discussion about what are our communities of interest? What are those things that bind us together, especially in this crazy, crazy world right now where we're looking for things to tear us apart. And I think, like John Kasich said a few years ago, we've got to start rebuilding our democracy at the local level. And I think defining communities of interest is a part of that.
Chief Justice, I wanted to ask you, as I think about just process, the Supreme Court has obviously said that these are judicial matters, but as you think about political questions coming to you, some required to come to you, but how does the judicial administration side, your clerks, your staff, how do you insulate yourself as a independent judicial branch from the the siren song of politics, when essentially everything is political? But you had a immaculate record as chief for being independent and fair. You would probably argue that it depends on who you ask about that, but I think you left the court with your reputation and dignity intact. But I'd love to hear behind the scenes, what do you discount? What do you easily discard to get to the part of the case that includes issues that you can adjudicate?
Well, I think I would start by saying all of the justices on the Supreme Court, and I believe other judges around the country, start with their oath of office, in which they solemnly swear to support the Constitution of the United States and of their respective states. That has been a statute in Kansas since the 1860s. And a few years ago, it became part of our Kansas Constitution. We also need to let people know that the court will not be intimidated. About 5 years ago, the Kansas Supreme Court was featured in an article in the New Yorker magazine. And it started by my State of the Judiciary speech that I had given, in which I was responding to then Governor Sam Brownback's State of the State speech that he had given to the legislature 2 weeks earlier. And he had pressured the Supreme Court on our pending school finance case. And in my speech, I replied that we do not decide cases based on pressure. And I just thought it was something that we needed to let the people of Kansas be reminded of. And instead, as everybody here knows, we make decisions based on the law, and that's the rule of law. And in particular, we don't go out of our way to antagonize anybody. Here, for example, legislators, they appropriate all the funds for the judicial branch of government, at least in Kansas. And in addition to that, it's in our practice, it's important for the litigants to believe they've been treated fairly and that all matters have been considered thoroughly, even if the decision goes against them. And it's not just the belief of the litigants, but also other people, as I mentioned. For example, we encourage the filing of amicus curiae briefs, friends of the court, to file their briefs in high-profile cases. In Kansas, all of our oral arguments are live streamed, so the citizens don't have to depend upon reading what some reporter said. They can see for themselves what we're doing. Those decisions, those arguments are archived. Since 2010, we have taken our court on the road away from our courtroom in the state capital of Topeka for the first time in our history. And we've gone to about 20 different communities. And several years ago, we had as many as 900 people from the community come to hear the oral arguments again, so people can see who we are and what we do and how we do it. Now, of course, we still take our share of flack for decisions that we make, particularly during the retention election time. We get some very pointed mailers sent. We also have doorknob hangers that criticize us, saying we should not be retained because of a single court decision that we made out of the hundreds and thousands that we've made during our careers. Just several days ago, there was another op-ed piece published that criticized our abortion decision from 2.5 years ago. This was a state senator, and I think she was gearing up her supporters and others for the constitutional amendment that's going to be on our ballot in August to change our constitution so our ruling does not have as great an impact as it does right now. So I don't want to paint us as heroes, but we do our job to the best of our ability. And I think it's important to understand, I think as Mr. Tierney and Bernie and the professor, the law of redistricting is not crystal clear. We get some very interesting decisions from the United States Supreme Court on what all this means and how the courts are supposed to be reviewing these plans that come before the courts. And recently, the US Supreme Court has been divided very sharply. Some might even say very bitterly. If you read some of the dissents written in these cases, the Shelby County case from, I think, 2013, Brnovich I talked about earlier. These are 5-4 decisions or 6-3 decisions, and they lay it out there for other courts to apply those principles. And I got to tell you, as I read through that case law, I say, this is not real crystal clear to me. And even, I think it was Justice Alito in the Brnovich case, or maybe it was Abbott or Perry, and he said, let's talk about the issue of race. We're not supposed to be considering race under the 14th Amendment, but the Voting Rights Act says we are supposed to be considering it. And I'm thinking, if you're pointing that out, Mr. Justice Alito, then what about the poor slobs out here in the hinterland trying to apply all this? And just reading through decisions, particularly of federal courts, they've got one standard for reviewing congressional redistricting plan, another one for state districts. And then if no plan was proposed by the state, you have one standard. But if you're trying to review a plan that there was one introduced, then it's another standard. And I'm not saying that judges are not used to handling complicated issues, but it seems to me they've made this pretty difficult.
Yeah, it's almost by design. They've painted an independent judiciary into the corner, and I appreciate your focus on maintaining an independent, co-equal branch of government approach, and just it is an entirely subjective because of the political overlay, but ultimately you're looking for some of those objective criteria, and there's so many competing demands that it's very difficult to sort out which one should be important in your ultimate review of a map, when a whole lot of other people would argue that some other criteria should take priority. So I appreciate your perspective and insight there. It's very interesting to hear you talk about the realities of trying to adjudicate those issues and maintain your independence and respect the rule of law and under a very tight time frame.
Exactly.
So
these cases seem to come not long before the Secretary of State has to say, okay, if you're going to run for an office,
right,
you need to get your name on in my office right
the
now.
the filing deadline is
exactly. And well, what district am I in? I don't know yet. It's up to the federal court or Kansas Supreme Court or others. And it's interesting, if I may, in looking over some of the case law under the Kansas system, at least once, maybe twice, when the Attorney General was following what the new constitutional amendment required, she was the only one who showed up to argue the case. And there was nobody else even supplying paperwork in support or against, except a state senator who said, yeah, I think it's a good idea. And then the Supreme Court said, well, even when it's not being objected to or challenged, you still have to
an independent, almost original jurisdiction.
And then the Supreme Court looked at the constitutional amendment and said, it doesn't say what the criteria is to determine if the plan is valid. So what do we do? And they went to federal case law, and they went to the Voting Rights Act and the 14th Amendment, one person, one vote. And then my understanding from an article a few days ago is that there are some people who specialize in this area saying, let's just stay out of federal jurisdiction. Let's look at the state constitutions and see if there's something there that we can hang our hat on and tell the feds that because you're interpreting a state constitution, they don't have any jurisdiction. We want to keep this in the state constitution, in the state courts. And in Kansas, for example, we do have a section of the Bill of Rights that does talk about equal protection of the laws, like the 14th Amendment. So somebody, whether it's Mr. Tierney and his band of attorneys general or law professors or experts there like Bernie in Colorado, they may be scouring state constitutions trying to find a separate path to do all this. I'm not saying it's going to work, but some bright minds are looking at it.
Yeah. Blair, do we have any questions in our queue?
We do not right now, no.
Okay. Well, I would encourage folks, if they've got a question for one of our panelists, I know we're coming up on close to our finish, and I'd love, after hearing this conversation, to give each of our panelists just the opportunity to reflect on anything that hasn't been said, something that they'd like to put on the table, maybe an interesting question that they have for just the future as we contemplate these things. but as we consider an audience of state government officials that are interested in how to do this and how to do this well,
I'd like
given
to just
collective
thank,
experience. So
I'd
Jane,
like to thank, yeah, I'd like to thank Lawton
Yeah.
and Bernie. I really learned a lot from both of you today. It was very interesting, not just about your own states, but in the attitude and the dedication that you brought to this process of trying to work our way through this seemingly impenetrable mess. I mean, it was very, very impressive, and I wanted to thank you for your comments. I learned a lot.
James, I have just one quick question about how AGs approach. You mentioned that once things get messy, the Senate hires their lawyer, the House hires their lawyer.
Well, increasingly,
So how do AGs balance, or do they just almost instinctively recuse themselves? But are there legislatures that look to the AG and says, we're not spending our money on a lawyer, you're our lawyer?
sure, that's the
And
default. The
Yeah,
default
how do
rule
AGs
is,
navigate that?
well, the default rule is that the Attorney General is going to represent the state, all right? And so
Yeah.
if they're actually able to come together and you have the legislature agrees and the governor signs or the commission votes, the Attorney General will defend that. And then they won't defend, if they're doing their job, they won't defend the specifics, they'll defend the process. They'll say to the court, this is the way it was supposed to work. And whether you think Joe and Mabel should be in that district or not is really not your job, Your Honor. It's
Yeah.
this process. And they will do that. My point is that as the wheels start coming off here, you're seeing individual legislators, bodies think that they can do a better job, the Attorney General, and they're almost always prompted by outside advocacy groups. It doesn't just pop into their head.
Yeah.
You're mentioning Carl Rove giving you a call. I mean, it doesn't just, some state senator, and I was in the legislature too, that wake up and say, gee, I think we're gonna do this. And then they'll say, don't worry about the cost. We'll provide all the money for you. It comes from third-party sources. Very, very dangerous. You want state government officials arguing state constitutional issues on behalf of the state. You do not want to have private law firms. You do not want to have individual legislative bodies doing that. It results in
the circus.
in a bifurcation, trifurcation in front of the court, and it makes the court try to settle things out, issues that should be resolved internally within the state. The AG can force that to happen if they are the spokesman. That's the rule you're supposed to have. But the wheels are wobbly, is my point.
Yeah. Well, Secretary Buescher, your closing thoughts or any reflections you'd like to have on this topic?
Well, I want to thank the council for hosting this. This is such important and meaty stuff. I know when I was in the legislature, it was one of those issues that it's easy to run away from because it is fraught with political anger and hard feelings. We've got to figure out as a nation how to get this right. The right of our citizens to have confidence in our elections starts with the belief that those elections are fair. And that's fundamentally that it's a district where their vote makes a difference.
Yeah.
And I think for too long, we have not done this as well as we should. All of us on this call are senior citizens, except David, perhaps yourself. I look at this and saying, this is one of those things that we should have done better a long time ago, but it's not too late to keep trying. So my 2 cents.
Bernie, the silver lining is that Colorado may teach us that out of the ashes, a phoenix can rise. And so even as we're distressed about some of the levers that are pulled in our election system and feeling the dust settling of a presidential election that was quite bruising, but it may very well be that galvanizes the strange bedfellows of politics to get together to say there has to be a better way. And I just want to commend you for exercising your civic duty, to leveraging your experience in the legislature and Secretary of State, to rallying a coalition, to doing the smart politics of getting the legislature backed into a corner with no other choice. I mean, you did it you were smart about the way you did it, but I think you served the common good in getting it done. And it's a great legacy to have. So I appreciate
You're way too,
your work.
I'll tell you one little thing, and it harkens back to the comment from the Chief Justice. One of the things that we were able to include in our 2 constitutional amendments was the codification of, I believe it's Article 4 of the Voting Rights Act, the protection for minority voters.
Interesting.
Because, there is some thought that the Supreme Court is going to say that is not the province of the federal government. And
Correct.
so, but we put it in our state constitution and everybody supported that. That wasn't a Democratic issue and that wasn't a Republican issue.
Not
Which is what
then.
we do. That's cool. I mean, that's why you do this, because occasionally you can say, we did something that was the right thing to do.
Yeah.
And it's good.
Yeah, that's a lasting legacy to be. Chief Justice, any closing thoughts as you think about this issue? Any advice or sage wisdom you'd want to share?
Well, let me close by thanking you and your very capable staff for setting this up. As Mr. Tierney mentioned, I too have learned a lot in this hour and a half. I hope that our audience has as well. A lot of people interested in this subject, and I applaud the people such as my fellow panelists who've been working on this issue. And for Bernie, my understanding is he's retired and he could say, I'm just going to go play golf, or I'm going to go skiing at Crested Butte. But I'm donating my time to work on this. And I just wanted to end with this disparity, if I could. I mentioned earlier in 2002, the state attorney general, you may remember Carlos Stovall, came to the Kansas Supreme Court per our Constitution and says, here's the plan the legislature passed. Nobody's here opposing it. The only other person who has anything to say besides myself is another senator. He happens to be a Democrat. I'm a Republican. We ask that you bless this, find it valid. The court went through its analysis, said, yes, it's valid. Okay. Fast forward to 2012, when the legislature could not pass a plan of any sort and had to go to federal court to have everything resolved, including our state board of education. I'm quoting from the decision, Essex versus Kobach, and it says, most of the interveners have unabashedly political reasons for intervening, and they seek to advance their respective political agendas by arguing for and against various maps that the legislature considered. So in 10 years in Kansas, a nice friendly state, you'll admit, right, David? Mm-hmm. They went from everybody agrees to we can't even agree what time it is. And the court had to sift through all of these arguments and go through the analysis and look at conflicting maps, and they wound up drawing some of their own maps. So I'm afraid in some respects, our world has gotten even worse since 2012. And I pity the judges, federal and state, who are going to be looking at no plans or a plan, trying to make sense of it and see if it passes constitutional muster.
Yeah, this is one of those areas where at the heart of CSG since 1933, we've been dedicated to one state learning from another state, from state officials learning from each other and sharing their knowledge. And I guess I reflect on politics has always been a very messy business. Stakes seem so much higher in moments like these highly charged political decisions than they probably should be. But it's actually wonderful to be in a country in which one of the manifestations of self-government is the intensity with which people pursue their self-interests. And hopefully in the mix of checks and balances, judicial review, and all of the political pressures brought to bear, we get back to those competing factions that our founding fathers wrote about so eloquently in the Federalist Papers. And the states are laboratories for democracy in this as well. The federal system works that one state can choose a course completely different from another. They can embed the criteria in a constitution. Others may have it be statutory. Some will have a very transparent system. Some may select to have it be purely the equivalent of a legislative fistfight for a scramble to see who can obtain a consensus. And I think in all of that, we need not reflect on just how messy it is, but perhaps reflect on, with some gratitude, on the fact that we have a system that can be messy. And I think for all of us interested in the continuation and the sustainability and resiliency of our democracy, of self-government, we have to find ways to make sure that there are guardrails around that messiness, that ultimately consensus can be achieved, that compromise can be reached, and that plans can be developed by the representatives of the people. So it'll be interesting to watch this unfold throughout the remainder of this year, and continue to watch as we think about how to redesign and evolve our political systems to serve the interests of the people. And that's the kind of sacred work that is worth doing. And certainly all of us at the Council of State Governments value our role in helping state elected and appointed government officials achieve the best aspirations for their state through programs and education like this. So to Blair and your team, to all of my colleagues at CSG, thanks for your attention in the pages of Capital Ideas and for sponsoring this breakout session. I loved having the conversation. The professor was fabulous. Bernie, James, Judge, you're all folks that represent the best public service, and your continuing interest in these issues indicates that your public service wasn't just politics. It was a commitment to the common good. And in that, you share the mission of the Council of State
Thank you very
Governments.
much.
So for
Thank
the
you,
good you're doing to build stronger and better state. Blair, back to you.
Thank you all again for joining us. If you missed any part of this, it is going to be ready for you on our website, which is I'll post here in the chat in just a second, and we'll have that ready in about a week. Otherwise, look forward to our next program, and we'll send out emails about that. Thanks for joining us.
Great.
Thank you all.
Thank you.
Be safe.
All right, bye-bye.